All right, I'm going to approach this problem from a little bit of a different perspective. A lot of these arguments are in an article I'm working on. It'll be coming out in the Stanford Law Review in May. I'd love it if people want to look at it on SSRN and provide me comments on this talk or on the paper. My focus here is to say there's a lot of ambiguity in Iqbal and Twombly, in part because the court didn't do a very good job writing these opinions. But I actually think that ambiguity might provide a different way out of the situation we are in, which is if we read those cases carefully and if we read them faithfully in light of what the court itself has said, both in these decisions and in terms of what it has said generally about how its decisions are supposed to fit together over time, the answer is a framework that does not have to be that different from the previous one. Now, there are a lot of examples of courts not doing that. And leading to the kinds of problems that have been identified by the speakers. But I'd like to put forward a theory by which we can avoid some of those problems. So let me start with some first principles. A lot has been said about what Twombly and Iqbal have done to the previous case law of the Supreme Court. But the fact is, it only deviated from one phrase in a previous Supreme Court decision. And the others, a lot of very lenient notice pleading oriented cases, remain good law. So let me talk about that one phrase. It's the phrase from Conley versus Gibson that a complaint should not be dismissed for failure to state a claim unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim. Now, I don't think this phrase was ever taken literally, and I actually give Justice Souter credit for criticizing it. So just imagine the following complaint. Paragraph 1, jurisdictional statement. Paragraph 2, the planet Earth is round. That's it. Can we really say beyond doubt that the plaintiff can prove no set of facts in support of his claim? Any number of actionable facts would be consistent with the Earth being round. So in my mind, the abrogation of that language is not all that troubling. What's far more telling, actually, is that Twombly cited with approval, really the core language from Conley versus Gibson was that the complaint must merely give a defendant fair notice of what the claim is and the grounds upon which it rests. Also, the court did not challenge other exemplars of the notice pleading framework, cases like Swierkiewicz and Leatherman. I won't bore you with the details of those cases. Well, maybe I will in a minute. But this is significant because, as a general matter, the court has made very clear, talking to the lower courts, that only it has the prerogative of overruling its decisions. And so even if there are potential inconsistencies, essentially, there's a duty to reconcile those unless and until the Supreme Court itself comes along and says, Swierkiewicz is no longer good law. The fair notice standard of Conley is no longer good law. My second first principle, and I'm not sure if that's an oxymoron or not, concerns what I think is the most controversial aspect doctrinally of Twombly and Iqbal, which is this inquiry into the plausibility of a plaintiff's claim. And I agree with the panelists that there are real problems with that inquiry. But I think if we read Twombly and Iqbal faithfully and carefully, plausibility really isn't the primary inquiry here. And at the 12b6 phase, it can actually fall away entirely. Okay, one thing Iqbal did was identify that there's really a two-step framework going on here. First, the court identifies allegations that are mere legal conclusions, that are conclusory allegations. And those don't need to be accepted as true at the pleadings phase. Second step is to look at the remaining allegations and accept them all as true. And then ask, do they plausibly suggest an entitlement to relief? So Iqbal itself makes clear that if the allegation is non-conclusory, it must be accepted as true without regard to plausibility. And if the crucial allegations, and they were in Twombly an allegation of an anti-competitive conspiracy, in Iqbal an allegation of a willful and malicious agreement by Ashcroft, Mueller, and 9 others to treat the plaintiff with harsh conditions of confinement as a result of his race, religion, and national origin. Had those allegations not been disregarded as conclusory, plausibility would have been irrelevant. And let me illustrate how that happens. Okay, let's assume that we have this crucial issue X. So in Twombly, it's the existence of a conspiracy. If the plaintiff provides a non-conclusory allegation of that conspiracy, then Iqbal's step 2 becomes, assuming X is true, is it plausible that X happened? Now, as a matter of pure logic, the answer has to be yes, because it's telling you have to assume that X happened, that it's true. The plausibility inquiry only comes into play if you have some crucial allegation that gets rejected as conclusory, and then you have to reason, well, given what's remaining, is it plausible that that now missing allegation can be established? So even if you're skeptical about the plausibility inquiry, as I am and many of my co-panelists are, it falls away if the plaintiff can avoid the scarlet sea of conclusoriness. All right, so this is, I think, where we might be able to solve this problem. And it involves getting into this question of what exactly is a legal conclusion for purposes of what you might call Iqbal step 1. The hitch here is that the Supreme Court in Twombly and Iqbal didn't provide much explanation for why the crucial allegations in those cases could be deemed to be mere legal conclusions. And I actually think this is the best and the worst part of these decisions. It's bad because that decision to deem them conclusory was a fundamental prerequisite for everything that came after, including this much maligned plausibility inquiry. So it would have been nice if the court had given us some guidance on that. But the silver lining here is that the court's omission gives lower courts and folks like us the opportunity to weigh in and fill the void. What I think is crucial in order to make sense and effectuate these two principles is to discount and dismiss what I think would be a profoundly mistaken way to read Twombly and Iqbal. And here's what that mistaken view is. The idea that a complaint needs to contain some kind of evidentiary support for its allegations, to whatever probability threshold, whether it's plausibility or something lower or something higher, and that without such evidentiary support, the allegation's conclusory. This is the wrong way to read Twombly and Iqbal, and I'll give you a couple reasons why. The first is, those decisions themselves accepted some allegations in the complaints as true, without regard to whether there were any additional allegations supporting their truth. So to give you an example, Twombly contained a lot of allegations about how the Baby Bells engaged in parallel conduct with one another. It never for a second says, well, wait, is there supporting allegations for those allegations? No, they accepted them as true. They were non-conclusory. Second, I think building on my first principle, is the Swierkiewicz case, which is still good law, actually explicitly confronted this question of whether a complaint needs to raise enough inferences of the ultimate allegation. And in that case, it was an employment discrimination case, and the issue was there actually invidious discrimination? And the court said that's not what pleadings are about. I won't bore you with the forms of the Federal Rules of Civil Procedure, but they contain some very bare-bones allegations on everything ranging from negligence to patent infringement that could not at all be reconciled with the reading of these cases that requires a complaint to contain some kind of evidentiary support. So then what does conclusory mean? And I think this is the tricky issue, but we're sort of forced here by the court's own actions because it's written an opinion that cannot set aside these earlier cases, cannot set aside these exemplars of notice pleading because of what the court has told us. But yet, we need to figure out why those crucial allegations in Twombly and Iqbal were problematic. So I'll just give you one example. I'll talk about Twombly, for example. Since I know we want to leave time for Q&A. Again, the crucial allegation there was that the defendants had entered into a contract, combination, or conspiracy. Now, by definition, a conspiracy to engage in parallel conduct has to come before the parallel conduct itself. Yet, the way this complaint was phrased, the conspiracy allegation came afterwards, and it was phrased in this way that suggested that the conspiracy derived from the parallel conduct rather than the other way around. It said that the conspiracy allegation was, quote, in light of, unquote, the parallel conduct. And Souter, in the majority opinion, emphasized this fact and said that because of that, the plaintiffs hadn't made an independent allegation of actual agreement. Now, my own view is that Souter misunderstood the complaint on this issue, that there were legitimate reasons why the Twombly complaint was phrased that way. But in terms of understanding what this means going forward, what really makes an allegation conclusory, it's clear that his concern was a transactional one. And let me tell you what I mean by that. It's not a problem that there isn't supporting evidence. The problem is when the allegation fails to identify adequately the real-world acts or events, the transactions or occurrences, if you will, that give rise to the claim. It's the failure to identify what happened, not a failure to show to whatever probability threshold that you can prove it. And I think if we take an approach like this, and I'll admit that there are tricky line drawing problems, but if we take this approach, I'm not sure we're necessarily that far off from the notice pleading framework that has prevailed. Now, someone will say, well, but wait, isn't the recognition that courts can disregard conclusory allegations a fundamental break from the old framework? I don't think that's true, because notice pleading itself was never a blank check. A plaintiff could never just say, defendant violated my rights in a way that entitles me to relief. That would never have to be accepted as true, even before Twombly. Now, pre-Twombly, the courts would have said, well, that allegation fails to provide sufficient notice. But the fact is, any approach to pleading that permits a court to disregard allegations because they lack some information the court deems necessary could be framed in terms of what fair notice is. So to say that an allegation is conclusory because it lacks X is no different than saying that fair notice requires the defendant to be informed of X. And this is exactly why Charles Clark, Dean of the Yale Law School, Second Circuit judge, and author largely of these federal rules, he bristled at the idea that the federal rules pleading standard was about notice, precisely because it begged the question of what notice was required. And if it required lots of details, that's not much of an advancement in his mind. So I think the need to define what conclusory means in this post-Iqbal era is going to force courts to confront this crucial question, which is what exactly must a complaint have in order for a particular allegation to be accepted as true. I'll wrap things up. Let me just say one more point before I finish up. I've certainly got the reaction sometimes that this is sort of a naive take on things, that I should be a lot more realistic about what the courts is endeavoring to do here, and that in fact the majorities in these cases are trying to do precisely what folks have criticized these decisions for, which is allow defendants, largely corporate and business interests, to avoid civil accountability. But I'm not sure that that's what was really going on here. I think if it was, why not overrule Swierkiewicz? Why not overrule the fair notice standard in Conley? Instead, they just overruled that problematic no set of facts language. I think what was going on, and it doesn't paint a particularly a good picture of the court, is that these are fairly result-oriented decisions that were motivated by the facts of these cases, rather than a desire to remake pleading standards generally. So Twombly was a mammoth class action involving nearly everyone who's ever had a phone. It would have lined the pockets of the Milberg Weiss firm, which had been indicted 1 month before cert had been granted. And then Iqbal was a lawsuit that was seeking civil damages against the 2 highest-ranking law enforcement officials in the country in response to what the court said was a national security emergency unprecedented in the history of the American Republic. So my sense is, this is not to praise the court in any sense, but I think we can not only read these cases, and that we're obligated to read these cases to reconcile them with the previous regime, but that there's also an explanation for why the court was particularly prickly about these cases. And I think that also helps, at least as sort of a realpolitik matter, explain that there might be hope when that next case comes, that we'll get some sort of clarification that brings us closer to the original pleading framework.